And good morning, you can be seated. The next matter before the court is Aroostook County, docket number 23418, State of Maine versus Kira Bernier. I see counsel are present. I'm assuming you are ready to proceed. I would ask that you start by identifying yourselves, saying your name for the record together with the party you represent.
Jeremy Pratt on behalf of the appellant, Kara Bernier.
John Ingalls on behalf of the state.
Thank you.
The appellee.
Thank you. We are being streamed live on the web by both audio and video, as far as I know. I think we had a few technical difficulties there, but I think that is now working. So with that, Mr. Pratt, we'd be happy to hear your argument.
Thank you and good morning. The trial court made two fundamental errors in this case, both of which were fatal, and demand that this court reverse and remand back to the lower court. I'm going to take them in reverse chronological order, but I'm happy to discuss either one as this court sees fit. The issue that I would like to begin with is the jury instruction issue. That comes down to a simple fact that the judge made an error in the case. This was a case involving a deadly force instruction.
Can we just set the stage, just a factual background on this? Correct me if I'm wrong in any of these facts, but these parties were living together in his house, correct?
Well, yeah, he owned it, but she had been living there since March or April of 2021, and the incident occurred in June 2025, so I would argue it's both of their houses at that point.
I don't think so.
Sorry, 2022.
Okay.
I apologize for that. June 5th, 2022.
So, but regardless of whether or not she had some sort of property interest in the house, she had been living there with his approval over this period of time.
Correct.
And they had a troubled relationship.
They did.
And he, in the past, had been violent with her on occasion.
Yes.
Including her and her son. On the day in question, the testimony suggested that he was intoxicated.
Yes.
So far. And he wanted her to get some more alcohol for him, and she had refused. And he became somewhat enraged. He pounded his hands on the counter, he punched the refrigerator, and he made a motion toward her. She retrieved a baseball bat from a closet, and as he approached, I'll ask the state again if you're in agreement later with these facts when we get to your side. She raised the bat over her head, and as he came close, she brought it down, striking him on the head with the bat. Is that correct?
Yes.
And at trial, she offered a self-defense on her own behalf, saying, I had to use a reasonable degree of force because he was coming at me, and I thought he was going to hurt me, and my kids would find me dead. Am I correct on the facts so far?
So far you are
okay.
Dead on.
So the court gave a self-defense instruction saying to the jury, basically, if you find she was acting in self-defense, you must find her not guilty. Just basic force and also deadly force. But the jury didn't buy that. They found her guilty. And you're faulting the judge's instructions at this point.
Yes.
What did the judge do wrong?
He got the law wrong. Simple as that. He indicated that when there's a deadly force instruction, he gave a deadly force instruction and said that she, the defendant, now the appellant, had a duty to retreat if she could safely do so. And that is an incorrect statement of the law.
But no one asked for that to be included in the instruction, is that correct?
That's correct. However, this court has said...
I understand, but should we, if in this case, I mean, when asked if there's any additions, changes, et cetera, to the instructions, defense counsel said, nope, they're good with me.
There's only one person in that courtroom who has an obligation to get the jury instructions correct. It is not the state, it is not the defendant, it is the judge. So
you're putting all of the burden on the judge regardless of any assistance from counsel. I mean, I agree with you that that's consistent with my experience as a trial judge, that I often got very little assistance from counsel. But isn't it the party's obligation as well?
Well, in this instance, which is unique, that the defendant's attorney objected to the deadly force instruction, so did not want it at all. And then the judge, on his own initiative, said, no, I'm going to give the deadly force instruction, but then screwed it up. The defense attorney, who didn't want it in it at all, that would have prevented any screw-up because it wouldn't have been in there. But
But
once
after
on,
the screw-up occurred, the defense attorney didn't step up and say, whoa, you gave the instruction, but you left out the last sentence, which was that she had no duty to retreat. Isn't that what this case is all about?
it is. I mean,
So we're reviewing this for obvious error, is your point?
no, I would disagree with that because he, the defense attorney, objected to the deadly force instruction. If that objection had been granted,
But not on the grounds that it didn't include, that there was no duty to retreat.
well, I would suggest if you use sort of the but-for analysis, but for the objection being overruled, we would not have gotten to that point, and therefore,
Well, then
the
let me,
appellant-
I'm sorry, but let me follow up on that. Then are you suggesting that if we agreed with you that there was an error, are you suggesting that we should be remanding it, saying it was an error to give a deadly force self-defense instruction in its entirety, or that it was incorrectly given?
I think that you should remand and say that once the judge decided to give the deadly force instruction, he had an obligation to get the law correct, whether or not the defense attorney objected or suggested that they needed that additional line in the instruction about there's no duty to retreat.
So you're not relying on the objection to giving the deadly force instruction in the first place on this appeal?
I'm relying on what I think will get the more favorable standard of review by the
Fair
courts.
answer, Mr. Kraft.
Let's assume obvious error. How do you distinguish the Pabon case, P-A-B-O-N case?
In several ways. In that case, first, I would ask this court to look at the excellent dissent that was in that
And
case.
who wrote that?
I can't recall off the top of my head, Your Honor.
Does sound familiar.
So, but in that case, the facts were simply vastly different. The defendant in that case rushes out of the house and sees law enforcement and said, I stabbed her, and immediately turns around, I think, and puts his hands behind his back and says, you can arrest me. The facts in that case, I think, were significantly worse than the facts in this case, where it generally comes down to a he said, she said, where she was relying upon self-defense purely. In the Papin case, if that's how you say it,
We said it Pabon, but it's
The,
speaker's choice.
there was a mental health defense as well. There was a confession. There were a whole bunch of other factors. But I will agree with the dissent in that case, and I would suggest to this court that maybe you should re-examine that case and consider overruling it and going with the dissent in that case to suggest that when the judge screws up the jury instruction and gets the law wrong, that should be error and it should be obvious.
Always?
Yes. If the law is instructed to the jury wrong, how can they make a reasonable decision when they aren't given the law correctly?
Well, isn't the test whether there's a reasonable probability that the result would be different?
Well, how can we know when they're not given the law? I think there's a reasonable probability that
So you don't like the reasonable probability test?
No, I'm saying I think there's a reasonable probability that a jury, if properly instructed, may come up with a different decision. I think there's a reasonable probability that a jury could come up with a different decision if they were properly given the law.
Let me ask you this. Let's assume that in this case, that the facts are as they are. However, crazy as it may seem, let's say the defense was the deadly force self-defense instruction. It may really not impact much of anything.
I say this with all due respect. I didn't quite follow the analogy, the comparison that Your Honor was given. May I ask for it to be given in a, I don't want to answer a question you're not
Let's assume
asking.
that in this case, I think the facts are that the parties certainly during the course of questioning and the state in the course of argument certainly focused on a duty to retreat. I probably skipped over that a little bit.
Okay.
That was raised.
Yes,
And it was clearly litigated, shall we say, right?
yes.
Let's assume, though, in this case, the defense had been entirely different. Would it matter if the defense was, when it comes to the obvious error standard, if the defense wasn't self-defense at all, but rather was focusing on, it wasn't me, I wasn't there, even though that seems absurd under these circumstances? In other words, if the defendant and the state, even though there was a mistake in the instruction, if none of them were paying any attention to that aspect
all right.
of it, because it wasn't central to their cases at all.
I apologize. I wasn't
No,
trying to
I'm
be
not being
obtuse.
very clear. It's okay.
I would revert back to the comments that I made to Justice Connors, that I think that it is an obvious error when a judge gives a wrong instruction, even if that instruction would seem almost absurd given the facts of the case. I think that error would remain. But I think what's unique in this case is that in addition to the judge getting the law wrong, he also interjected himself into the case by the questioning of the defendant and questioned her veracity and truthfulness while she was testifying.
And that's your second point on appeal.
It is our second point.
So the judge did intervene with the witness and said several times, testify truthfully in the greater context of things, correct?
But I don't think it's just say testify truthfully. He was engaged in a back and forth and took over questioning from the states.
Well,
And
she
when
was,
you
as you know, as a trial lawyer, which you are, occasionally you get a witness who is very uncooperative and push off. And as a judge, as a trial judge, I used to leave it to the lawyers to work it out. But if it wasn't working, I would step in and say to the witness, okay, just answer the questions being asked, give the shortest answer that completely answers the question being asked. And I would probably throw in, and your answer under oath must be the shortest. Is there something wrong by addressing an uncooperative, resistant witness to testify appropriately and responsibly and truthfully? Where's the problem with that?
I always hate lawyers who just throw bouquets at judges, but so I can't help in this instance. That's the way that a trial judge should have done it, right? Which is keep your answers short, answer the questions. In this, as you saw, there was a level of frustration. The judge took over, was going back and forth, then at the end was like, you have to tell the truth, which is a clear signal to the jury that the judge does not believe that she's telling the truth. So if the court had done what Your Honor was suggesting, which is to say you have to answer the questions, you must answer them, not a different question, you must do it succinctly, that would be entirely appropriate. I would not be making that argument today.
Well, he used varying levels of intervention,
Yes.
saying the court's unclear as to whether the witness truly understood the questions. Please ask it again. If you don't understand, please let us know. And the same thing happened. She's pushing back and being uncooperative. And then the court finally at some point, well, the question, this is where we're getting bogged down. The question is, do you recall making a statement to the trooper? Yeah. Either you remembered saying that to the trooper or you don't. That's the question. Do you understand what the question is, yes or no? She says, yes. And he says, okay, do you recall telling the trooper you pushed the victim? She says, I did not push the victim. He's like, the question is not whether you did it or not, it's whether you told the trooper you did. What's wrong with that?
Well, I think it's, one, our opinion is that should be left up to the two attorneys and that the judge's involvement should be as minimal as possible and that they should not be intervening and putting their finger on the scale on one side or the other.
But what if you have a totally out of control witness and the lawyers aren't being effective in moving forward?
Well, I think then the judge should probably take the attorneys into chambers and explain that they're being utterly
What I thought I
ineffective.
heard you saying is the judge should not intervene at all, but then you said, and putting a finger on the scale. I mean, those are two different things, aren't
Right.
they?
Sure.
Clearly, a judge cannot truly put a finger on the scale, but are you suggesting a judge can never intervene?
No, of course not. They can intervene when it's appropriate, but I think in very limited circumstances, and that intervention should be as limited as possible to allow the parties. The party presentation rule should be.
And I note that your time is up.
Oh, I'm sorry. I didn't realize that was. I'm not colorblind, but that seems a little.
I understand.
A little more.
And I'm going to suggest, it seems like you might have abandoned your argument that a baseball bat is not a dangerous weapon.
I will rest on the brief on that argument. Thank you.
Thank you. Yes?
We maintain a baseball bat is a dangerous weapon. So the question that, one of the issues that we focused on in the earlier part of the argument here was the question of the self-defense statute. And so under the self-defense statute, to use deadly force, the appellant would have had to have reasonably believed it was necessary and reasonably believed, A, that the person was about to use unlawful or deadly force against her. There wasn't any evidence presented at trial that he had ever used unlawful deadly force against her. That evidence simply wasn't presented. I'm going to skip over Section B because there's no question that Mr. Wisbecki had a right to be present there. So Section C applies only where paragraph A applies, and that's where Section C, of course, you know, is where the dwelling place exception is found. So if we return back to Section A, there simply was no evidence that he had ever used deadly force against her. She did not say that. She alleged that he had done non-deadly force at different times, but at no time did she say that deadly force was used against her, and so the dwelling place exception would not apply. The first and the other argument deals with the judge's intervention. In our brief, in the state's brief, we talk about a couple of different cases that were raised by the appellant in her brief. They're asking that it to be compared with State versus Annis, where the court figuratively removed his robes and donned the humble attire of an attorney and proceeded to cross-examine the defendant, apparently very effectively for the state, for what appears to have been about 10 minutes, and dealing with, among other things, imposing upon the defendant of the burden of producing evidence, which the defendant does not have, specifically producing a Mr. Simpson. In that case, the defendant actually preserved his right of appeal, moved for a mistrial, and that also did not happen in this case. The appellant also asked us to look at Price versus State, Georgia case, where the court directly asked the witness if she was lying 4 different ways. Here, the appellant in her brief specifically says that the court did not attack her veracity. So none of that happened in State versus Bernier. Here, the court just simply tried to get Ms. Bernier to answer the questions. And
Counsel, I see that the green light is on. Can I return you to the deadly force issue? You have indicated that she never said that he had previously used deadly force on her, and there's also no question he didn't seem to have a weapon at the time of these events, correct?
Correct.
But didn't she testify that in their previous altercations he had put her in a head hold or chokehold of some sort?
I don't recall that at the moment.
If so, that would be evidence that he had indeed used deadly force upon her in the past. Isn't that correct?
Well, a head hold would be different from a chokehold.
Okay. Well, let's put it this way. Our statutes recognize that strangulation
Right.
is essentially deadly force because it carries with it choking somebody carries with it the potential for killing that person, right?
That is correct.
Okay. So doesn't her fear of him, if based on his prior, doesn't that create the need for a deadly force instruction?
Well, I agree that, State versus Wallet, 2012, in that case, the court specifically said that providing both instructions was necessary for, the language used, I believe in the footnote, was that providing both instructions was a flawless way of providing those instructions.
Right. The jury certainly could have found that he was not, there was no reasonable fear of deadly force from him. But there was at least the possibility that they could have, and that's why the judge used a deadly force instruction, we assume, right?
Right.
So if there is a deadly force instruction, don't you have to make it complete so that it's clear that there's no duty to retreat in the dwelling?
I don't believe that on this occasion the evidence supports that she believed that reasonably believed he was about to use deadly force upon her.
Well, she did testify. I mean, her testimony said, I recited the facts earlier to Attorney Pratt, and it included his history of violence to her, and that he was enraged, he was intoxicated, and he was coming at her. And I forgot her exact testimony. She's like, I was afraid my kids would come and find me dead. That's how she testified. So at that point, she had a fear of imminent bodily injury or death due to the use of deadly force. And the question would be for the jury whether or not that was reasonable. But when we look at it from our perspective here in the light most favorable to the state, we still see the fact that she expressed a fear of death or imminent bodily injury.
That was, when the appellant was speaking earlier, you asked him for a recitation of his facts.
Yes.
And in viewing the facts in the light most favorable to the state, I don't believe that includes the defendant's interpretation, because it's most friendly to the jury, the determination that the jury came to.
But we have to include that when we talk about the issue about whether the deadly force self-defense instruction was generated, don't we?
I agree with that.
Okay. And so I'm going to go back to the question I was asked. If we assume it was generated, how do you address the fact that the judge did not identify for the jury that there is no duty to retreat in your own dwelling, when in fact the state, you argued that she should have retreated?
Well, I did argue that she should have retreated. There's two things I guess I would say. The first is that the defendant, through representation, did not object to the instruction as given, and in fact objected to a deadly force instruction being given at all. Had there been no deadly force instruction given, the defendant, the appellant, would also not have received the dwelling place exception, because that's under the umbrella of the deadly force instruction.
But it was given.
It was given, yes.
So what do we do with the fact that he didn't instruct on the duty, that there is no duty to retreat, when you explicitly argued to the jury that she should have retreated, and in fact that is contrary to law?
Well, the question is, did it meet the obvious error standard? It wasn't obvious to me. It wasn't obvious to the defendant's counsel. And it wasn't obvious to the judge.
Well, when we look at it after the fact, we determine whether or not it may have affected the outcome of the proceedings here. So the jury hears this instruction. The judge said, a person is never justified in using deadly force if she provoked the encounter, or if she knows that she can retreat from the encounter with complete safety. If she knows she can retreat with complete safety. So the jury heard, well, she could have gone back in the house, she could have gotten to her car, she could have done this, gone here or there. Gosh, she could have retreated with complete safety.
Gone in the bathroom, locked the door.
All sorts of things. And that came out during the direct examination, cross-examination, arguments to counsel. That she could have taken herself out of this picture here. But what the jury didn't know is the exception that she has a duty to retreat, except that the person is not required to retreat if the person is in the person's dwelling place and was not the initial aggressor. So the jury thought, if the jury heard that, they would have said, oh, she didn't have to retreat. We'll find her not guilty.
Well, so if you'll recall, because of course you've well reviewed the case, she actually did indicate to the jury that she did retreat. If you recall, she said she was standing before Mr. Wisbecki, and she turned and went to the closet and grabbed the baseball bat. So she retreated and then was ready to go.
There is no duty to retreat if you're using non-deadly force, as I understand the law. In other words, the duty to retreat exists only if deadly force is being used.
Correct.
And so it seems to me it's a little hard for the state to argue that the deadly force wasn't generated when the state persisted in cross-examining the defendant on why she didn't retreat, why she didn't leave, etc.
Isn't that the centerpiece of the case, whether or not she could have bailed out and not have to use the bat?
Well, I don't think so, because I personally think that the centerpiece of the case actually dealt with, because the defendant, the appellant brought it up in their brief, was the question of the defendant's credibility. And the reason I say that the appellant brought it up in her brief is because there's a section where the appellant refers to what happened in sentencing, and it's basically to make the argument that the appellant lacked credibility because of the judge's intervention, and saying that the judge never believed her credibility. I don't believe that that was established at all during her direct examination or cross-examination. I believe that the crux of the case was actually when Trooper Martin testified and indicated that her child, who did not have a bruise on the day that he first interviewed her, and then later met them again, did not have a bruise, and then found that there was a bruise that she attributed to Mr. Uzbeki 2 to 3 weeks before.
So you're talking about the history of violence that may not have been credible.
Right.
But again, as somebody said in a dissent in Pabon, the issues of credibility are for the jury, not for judges or lawyers to consider after the fact. But if I'm sitting there as Joe Juror, and I hear these facts, what happened with the bat and all the rest of it, and the judge tells me, yeah, she had a duty to retreat. I'm thinking, she didn't retreat. Self-defense doesn't apply. She's guilty. Even if we use an obvious error standard, isn't that a very critical tipping point on whether or not she's going to get off on self-defense or not?
Well, I still don't think it's obvious error. So you would the fourth part of the obvious error test is that the error seriously affect the fairness or integrity or public reputation of the judicial proceedings. In this case, I don't think that it affected the fairness or integrity or the public reputation, but specifically with those two, because first the appellant had a chance to request that instruction. We were all dealing with the jury instructions on self-defense at the time, and the defendant did not make that request. And that goes directly to the issue of fairness, because the appellant had as much input as did the state, as did the court.
Well, that happens in every case where we have obvious error. They don't bring it up. So that argument really doesn't wipe out the opportunity for prevailing on obvious error, because we only look at obvious error if it hasn't been raised previously and in an unpreserved way.
Well, I'm not sure it wipes out the argument, because that's why the test is there. That's why the test is established for obvious error, as it is.
Right. So we have to decide, was there a reasonable probability that this could have affected the result, the outcome? The jury could very well have found for her, for the defendant.
I understand. And I don't think that it would have affected the outcome there.
It wasn't possibly suggested by virtue of the fact that the jury did not have the complete instruction that pertained to the self-defense that the defendant actually objected to, but the court decided to put it in. They didn't have the full law stated to them, so that they could deliberate in view of what the law was, the correct version of the law. Isn't that problematic?
Well, the question is whether it meets the obvious error standard, and what I'm arguing is that it doesn't.
Can I ask out another aspect of that? In your brief, since I asked this at the last minute about the dangerous weapon for Mr. Pratt, in your brief, you suggest that she did indeed have the duty to retreat, that it was a correct statement of the law because it was not her dwelling place. Are you asserting that?
Well, he had asked her to leave.
He had asked her to leave, but you have to agree that she had no other dwelling place at that point. She'd been living there for quite some time.
Well, she had a dwelling place the next day.
Well, once she was kicked out, but that night, in fact, even after she hit him with the bat, they both went to bed in that house, didn't they? Separately.
It is true, but however...
in fact, he didn't call the police until the next day when he thought, well, that's a good way to get her out.
Well, I don't know what the
Go ahead and answer the question.
If you recall from the transcript, she had actually moved in with her sister several times throughout the course of the relationship. She didn't have trouble finding another dwelling place for herself.
Okay, thank you. And Mr. Pratt.
What I love to do at a trial is when I'm doing my closing arguments is weave in something from the jury instructions to my closing arguments to help validate what I'm arguing because the judge has just said it or is about to say it. I apologize if I started prematurely for the...
Okay. Actually, the timer was going, just the light wasn't on.
So I try to weave in the jury instructions, and to the state's credit, they did that in this case. They did it during the cross-examination. During trial transcripts 143 to 145, 149 to 152, I will quote from the state. You stayed, you didn't run. You didn't run, you stayed. You stayed, you didn't run. These are all different sections. So instead of running from somebody, you stayed, on, and then that same argument is made during closings, which is what a good trial attorney should do, building off the jury instructions. The problem, though, in this case, the jury instructions were wrong. So if the court, which I think is leaning towards an obvious error standard, maybe, instead of the standard that I was suggesting, I would argue to the court that the combination of the closing arguments and the questioning, where the state's thrust of their argument is that she should have run, because the state argues that and says that, I think 13 times, 14 times, that the combination of that two should elevate this case to the obvious error standard and should result in a reversal.
To Mr. Ingalls' point, does this affect the fairness and integrity of the judicial proceeding?
I would say 100%. As I said during my initial statement, that the obligation for the court is to get the law right. Unequivocally, the court got the law wrong. Errors happen. Judges are human beings.
I take it you don't agree that this wasn't her dwelling place.
I'm sorry?
I take it you don't agree that this was not her dwelling place.
No, I think it was obviously her dwelling place, and I'm happy to go into details why, but I do not think that's necessary. If there are no further questions, I will relinquish the remainder of my time. Thank you.
Thank you. Thank you, counsel, for the argument here this morning. As you may have noticed, we had quite an audience with a school group here. As is our usual practice, however, we do not issue our decision at this time, but we'll take the matter under advisement and issue a written decision in due course. And with that, we are in recess on this matter.
All right.
And good morning. You can be seated. The matter before the court now is Carol Cutting versus Down East Orthopedic Associates. This is docket number Penobscot 23410. I see counsel are present. I'm assuming ready to proceed. If counsel who would be arguing would identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Laura White for appellant Carol Cutting.
And Christopher Tainter for the appellee, Down East Orthopedic Associates.
Thank you. And we are being streamed live on the web, both by audio and by video. Attorney White, if you are ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. Good morning, and may it please the court. Although this appeal involves a lot of complex issues and many different issues for your review, this court can easily dispense with this appeal based on de novo review of the trial court's grant of a Rule 50 motion involving punitive damages. Criminal conduct, as alleged in this case, if true, is sufficient to justify an award of punitive damages, full stop. If the Maine legislature didn't find that a doctor falsifying a medical record, as alleged in this case, were reprehensible and outrageous, it would not criminalize it. The trial court agreed that the conduct alleged against Dr. McGuire was in fact outrageous. However, the court viewed the sequence of events as essentially an after-the-fact self-protective measure, if true, that we allege Dr. McGuire engaged in because he failed to obtain informed consent, and then covered it up by doctoring up a medical record, which is a crime. It was not for the trial court to decide what Dr. McGuire's motives were. That was for the jury to decide. And there are two important points that I'd like to make about the punitive damages claim. First, the Downing's argument about vicarious liability, which was never raised below, never briefed below, never discussed with the trial judge below, and it's been abandoned on this appeal under this court's precedent in Jones versus Secretary of State, 2020 Maine 113, in which this court held that if a cross appeal is abandoned, that an alternate basis for finding or for granting the Rule 50 motion cannot be brought. So we have a waiver of the issue below, and more importantly, there's no citation in defendant's brief whatsoever about vicarious liability not being available in a case where we allege not only negligence in the lack of informed consent, but then followed by an intentional reprehensible act. The other issue is harmless error. I understand it's easy to conclude that, well, the jury didn't find for you anyway, so they weren't going to find punitive damages. But we all know that, especially in a case as close as 6-2, we had two jurors on our side, that it can persuade a jury. Maybe one of those jurors concluded that they didn't feel the need to compensate Ms. Cutting because her arm was healed. They knew she was a recipient of Social Security disability benefits. Maybe they concluded she had Medicare and she didn't need to be compensated, but they wanted to punish and deter Dr. McGuire's reprehensible conduct. It was stated in opening, and then they heard in closings from Down East, that's not an issue in this case. You can't, this is just about compensating her. You can't punish the conduct of Down East. If just one juror were persuaded by that, and that means that they decided, well,
I'm going to stop you there for a moment. I see that the green light is on. So in this case, this was an informed consent medical malpractice case. I mean, I know there were other pieces to it, but at its heart, right, this was a lack of informed consent.
Correct.
Or the allegation was a lack of informed consent to the surgical procedure that was done, right?
Correct.
And then when you're referencing the criminal conduct, you're talking about the allegation that Ms. Cutting made that Dr. McGuire, in this case, had essentially falsified the operative note afterwards, right?
Correct.
Or at some point. But you opened up your statement by saying, I mean, when it went to trial, the jury found in favor of the defendant, the doctors, right?
Correct.
So you opened up your argument by saying criminal conduct is enough to justify punitive damages, full stop. Are you suggesting that punitive damages are in fact awardable for egregious conduct even if there is no underlying tort?
No, that's not what I'm suggesting. I'm suggesting that it's very possible it prejudiced the jury to such a point that it was harmful
But
error.
your argument about harmless error as well, they could have thought that maybe she didn't need to be compensated. But isn't that the problem here, is that regardless of whether there was sufficient evidence to generate a punitive damage instruction or to allow it to go to the jury, that having found that there was no medical malpractice to begin with, the jury can't award punitive damages?
I think that I agree with that premise, but the point that we're trying to make is harmless error is not our burden to prove that it wasn't harmless, that there was no prejudice. It is Down East's burden to prove that there's a substantial certainty that this could not have influenced the jury at all, the mere fact that the punitive damages claim was thrown out.
But the jury didn't find any negligence on the informed consent claim.
Our point is that the jury may have rendered a different verdict and reached a different result if instructed. Plaintiff's counsel told you in her opening that punitive damages were at issue if proven by clear and convincing evidence. The fact that they are then told by defense counsel in closing, no, that's not at issue in this case, makes it look like I'm telling them something that legally we believe should have been allowed for them to decide.
Isn't that a danger of overstating your case, though, in the opening? I mean, lawyers, you've done trial work before, and if you say, we're going to show A, B, C, and D, and during the course of the trial, C doesn't come in, the jury goes, well, so you misled us.
I think that's the crux of the issue, though, because we believe it was an error of law to not allow punitive damages to go forward. If that had not happened, then that statement made in opening would have been entirely consistent with the jury instructions.
But if it was error not to allow punitive damages to come in, you would prevail on that on the appeal, and the point you're making about the opening statement becomes moot. Doesn't it just engulf it?
I think had defense counsel not in closing reiterated to the jury, they mentioned that in opening, but that's not at issue in this case.
But isn't that the defense counsel's job to say, you're not looking at this thing? Maybe you thought it was part of the case, but it's not part of the case. What's wrong with that?
Sure. I think there's nothing wrong with that if the decision in the Rule 50 realm were correct as a matter of law, but it was not.
Can I ask you about some of your other issues here?
Sure.
You're aggrieved by the screening panel process. I mean, you're very dissatisfied with that. And as we know with the screening panel, there's a group of 3 people who kind of hear the evidence, but it's kind of, a lot of stuff comes in or doesn't come in at that point, and they can come up with a result that the jury hears about that makes a difference to the jury. But we have said in the past that, the screening process is constitutional, it is okay, and you'd have to overcome that precedent that exists out there. Why should we make a sea change in the previous decisions by the court?
So the screening panel process was, in my experience, extremely bizarre in this case. Weather starting that off just because there was a snowstorm. But the fact, and I think common sense needs to dictate here, the common sense understanding that the screening panel would absolutely never say to a medical provider, we don't need a hearing, we've already found against you. The trial judge...
Let me interrupt you. You've got 4 minutes left. I want to make sure Are you asking us to throw out the screening panel process or say to the Superior Court, take a look at what happened there, and if you don't like what happened, then don't give the instruction? Which of those are you
Correct.
urging?
So in the panel phase, my argument to the chair was, if you want to render a decision because you've consulted with the panelists and you all agree that there's a decision you can render, we can't tell the jury there's been a hearing. That's factually incorrect. You've decided the case on briefs.
There was a hearing.
There was, but essentially there was a back and forth with the panel chair where she said, I've talked to the other panelists, which frankly disturbs me in and of itself, to go to panelists and say, we don't need a hearing here, do we? But essentially, that's what happened. She said, do you want to move forward with a hearing? And I said, if we don't have the typical Irish instruction that lets a jury know that a hearing was held, all of the instructions, defense counsel's response was, nope, they will get the Irish instruction, it will be the way it is, and that's just fundamentally flawed.
Okay, but under Rule 80MB4, if you want relief for cause based on the conduct or inaction of the chair, you have to promptly state the objection by letter to the CJ, the Superior Court, and get a ruling. Did that happen here based on what you thought was inappropriate conduct by the chair?
It did not, Your Honor, because my
Isn't
view...
that your remedy?
I don't think it is under a state of Nickerson, because I think it's very clear that when Rule 80M is not followed, those panel findings are inadmissible.
But in a state of Nickerson, what happened was that there was evidence after the fact that essentially that they had considered in rendering the decision after the hearing some additional information outside of the record. Here, what you're saying is, it seems to me that when you said you didn't really need a hearing, you've prejudged the case. Now, I will say as a judge, the fact that I might indicate I might not need a hearing doesn't tell you which way or if I have prejudged the case. But putting that aside, if you thought that was misconduct, indicating bias or the prejudgment, consultation with the others, I mean, Rule 80M provides the avenue for how to address that, and that didn't happen here.
My read of that rule is that typically that's for a process when something happens early on, which it did in this case as well, when the panel chair made an offhand comment about the nature of the claim in this case. And you're aggrieved by that, and you have the ability to raise it with the Chief Justice. In this case, it essentially, the process was completed, and I was being told, we've decided the case.
Well, no, the process wasn't completed. They were telling you that before you actually had the hearing.
Correct, only because I said we still want a hearing, but I think it was...
Which you have the right to do and had.
Correct. I think the issue, though, is the panel findings are just a piece of evidence. It's just an evidentiary matter. And Rule 80M, the state of Nickerson, is clear. If you decide, if those panel findings are based on something other than what happened at hearing, they should not be admitted. And it's unconstitutional. This panel absolutely, I would say more egregiously than in Nickerson, decided without any hearing at all.
But that's really your assumption, isn't it? I mean, I guess to say that, well, they said, well, it got canceled because of a snowstorm. We could, instead of rescheduling this, we can hear it on the record, i.e. the depositions and the other exhibits, panel submissions. You're assuming that's a prejudgment, but there's not actually evidence that we can look at that says it was.
There's not evidence that says which way they decided,
well,
but
there
there
is evidence
is
saying it's a prejudgment.
There, I don't know if it's in the record. It was in the trial court. May I finish? Or,
yes, you may.
In the trial court, there were emails exchanged and motions in limine where the panel chair did say, I have confirmed with the other panelists we have enough information to decide this case without a hearing.
Right. We have enough information to decide it, but it doesn't say which way. Am I correct?
Yes, you are correct.
Thank you.
Thank you.
Mr. Tainter.
Good morning.
Good
May it
morning.
please the court. I want to address the issue of punitive damages first. As I argued in our brief, first of all, I want it to be very clear, and I think it is clear from the brief, that we categorically deny the accusation that Dr. McGuire falsified the medical record. Even if that were true, however, even if, and the jury obviously found that he did not, but even if Dr. McGuire had done that, the trial judge made a completely reasonable and thoughtful decision that the falsification of the medical record did not contribute to any harm to Ms. Cutting because, as Justice Stanfield noted, this was an informed consent case. If there was harm, the harm occurred the moment the surgery occurred, not later in that day or the next day or whenever it was that Dr. McGuire wrote a note in which he wrote
But
that
doesn't his actions, I understand that that's what it was really primarily based on, but doesn't that also inform, let's assume, I understand you deny it, but, and the jury didn't find liability, but assume he had falsified the record afterwards. Doesn't that also inform the plaintiff's claim that essentially she was treated in a callous and frankly discriminatory manner, and that there was actually outrageous behavior that was so outrageous that malice could be implied?
Well, I think there again probably was sufficient evidence. I mean, clearly there was a factual dispute about this. There was enough evidence for a jury to conclude, based on Ms. Cutting's testimony, that Dr. McGuire had falsified the record. The question was whether or not that outrageous conduct, if it had been established, contributed to the commission of a tort or was related to the commission of a tort. And I think that goes to this whole question, frankly, the very opening statement by Attorney White, that outrageous conduct gives rise to punitive damages, full stop. That's simply not true.
So it's you're going with the language, I think it comes from Tuttle, that it must be the tortious conduct itself that is so outrageous that malice toward the person injured as a result of that conduct can be implied.
Absolutely. I mean, there are all kinds of things that people do every day. We're coming off an election cycle where people did outrageous things all the time and said outrageous things. That doesn't make them tortious because there's no actionable conduct toward a particular individual. And so, and again, if we talk about this whole concept of, or the allegation that Dr. McGuire treated Ms. Cutting in a discriminatory or dismissive way, again, that in and of itself is not a tort.
Can we talk a bit about the screening panel
Sure.
process? To what degree can a med-mal plaintiff attack the goings-on of the screening panel during the course of the actual jury trial that occurs after the fact? Is there any door that allows them to say, well, you did hear about this thing that happened there, but is that permissive? Is there any avenue to do that?
Are you asking about in argument to a jury?
During the course of a trial, maybe trying to bring evidence in as to what happened at the panel?
I think you clearly can't do that. That's clear under a state of Nickerson.
Okay, how about during argument to the jury?
I think we're limited to the Irish instruction. I think
Is
this
there a
court has
due
said that.
process problem here? Because the screening panel process, as you know, is a unique animal that was created. Things go on there, it's very informal, the panel chair is given a fair amount of discretion, and it's quite possible that something weird, untoward may have happened there. But you're telling me a plaintiff is stuck with that they can never really get redress for any process that went sideways during the panel when it comes to the actual trial itself.
Well, I mean, I understand the argument. I guess I would say a couple of things. One is this court has said on multiple occasions now, I think, that the panel process withstands a due process challenge.
Right.
Here, there hasn't really been a frontal due process attack on the system as a whole. If there had been, plaintiff's counsel, appellant's counsel would have had to involve the state, and the state would have had to be here to defend the system. In fact, we had that issue with some post-trial motions that the appellant filed, where there were challenges to the confidentiality of the panel process.
But in this case, it wasn't really a full frontal attack, as you said, on the constitutionality so much of the statute that establishes the process, but she did attack how it happened in this case. I mean, in other words, that it was an unfair process in this case.
Right.
Whether or not it might be unfair in other cases. Did she do that in the right way? In other words, she moved in limine to keep out the panel findings because it was the result of a very unfair process and therefore should not be accorded any weight in front of the jury.
I hope that what you're saying is you're characterizing her argument as opposed to your conclusion.
Well,
Time will tell.
Time will tell on that, Mr. Tainter. As you know very well, I did many, many of these proceedings back in my day.
Right. I mean, I don't take issue with the way the appellant raised the issue in the Superior Court. I think the Superior Court reached the right result by concluding that it was impermissible to analyze what had gone on at the panel stage. I mean, even in the state of Nickerson,
But then what is the remedy? Let's assume you're right, and you're not going to raise it in front of the jury or as part of the instruction, et cetera. But if you raise it as a motion in limine, in other words, that the panel result shouldn't go in front of the jury, that it should just be set aside for purposes of this trial, because the process in this case was so fundamentally unfair. I mean, are plaintiffs, or for that matter, if it should happen to a defendant, although I think that would be extraordinarily unusual, hands completely tied in raising that fairness of the process when it was, let's say, really was fundamentally unfair?
Well, you know, it's hard to think of a situation in which it would be possible to challenge what went on sort of behind the curtain, if you will. I will say that there have been cases where defendants, respondents, feel that they've been treated very unfairly because, for example, you're allotted a certain amount of time during the day to have a panel hearing, and the claimant takes up the entire day with their case, and the respondent never has a chance to put on evidence. And I will also say that, Attorney White's assertion in a brief that these cases never result in panel findings for claimants is just simply wrong.
I'm aware of that.
Yeah, it's unsubstantiated. So,
But how often would a panel tell the parties that they've been able to reach, they can make a decision against the physician based upon the record? Realistically, how often would that happen?
well, first of all, I don't think I've ever heard of a situation where a panel said, without having had a hearing, we've made a decision based on the papers. And I don't think that's what happened here. They said, as I think Justice Stanfield pointed out earlier, or maybe it was Justice Connors, they said they had enough information to make a decision. They didn't say, we have enough information and we've made a decision. They said basically, look, we have all of these deposition transcripts, we have
Medical records, arguments of
medical
counsel
records.
in writing, et cetera.
But the reason these panels exist is so that the healthcare providers and the lawyer and the former judge can sit together and deliberate on the cases. I don't think any lawyer or former judge makes a decision about a medical issue without talking to the physician who's on the panel. So just because they had enough information doesn't mean that there wasn't going to be some collaboration among the three panel members to reach a decision about what the result should be. I mean, it's completely unfounded, in my view, to suggest that there was a decision here made before the panel hearing that the claimant had no case. The panel was doing everybody a favor, frankly, by saying, look, we've had this, we've had this snowstorm, we can't hold the panel hearing. You have a couple of options. We can have a hearing sometime in the future, and as we know, claimants are often upset about the delay that occurs during these panel proceedings. So one option is we can have a panel hearing someday, or we can make a decision now based on the papers. Attorney White said, I'm okay with deciding it on the paper as long as the Irish instruction omits the reference to a hearing. Attorney Lavoie, who was lead counsel at trial, said, no, we should have the appropriate Irish instruction, and if that means having a hearing, we'll have a hearing. So they did. But it seems completely unrealistic to suggest that these three panel members who take oaths to follow the law made a decision without carrying out their duty under the law.
On the punitive damages issue, the trial justice found that the alleged conduct, if it occurred, indeed would be outrageous.
Right.
How does that how does that relate to the decision to exclude the evidence if it met the outrageous threshold?
Well, he didn't exclude the evidence. The evidence was in all throughout the trial. He concluded that.
Right, excuse me, I meant
Yeah.
preclude an award of punitive damages.
Right. I think his analysis was exactly right. His words were the damage had already been done, and that goes to my point that in an informed consent case, if there's damage, it occurs when the patient undergoes surgery, not later on. So let me just give an example. If when I'm driving up here today, if I had been in a car accident because I'd been texting while I was driving, and I got stopped by the side of the road, and while we're waiting for the police to come, and I throw my phone in a ditch. Throwing my phone in a ditch is outrageous conduct. It might even be criminal conduct, but it doesn't contribute to the commission of the tort. The tort is my inattention to driving and causing an accident. It's really the same thing here. We're talking about an allegation that there was a fabrication or misrepresentation or
You're saying
alteration
that
of
the
the
injury
evidence.
has to occur as a result of the outrageous conduct.
Exactly. I think that's clear.
Okay. Can I move to another argument that you
Sure.
made? And that is that in this case, the defendant is actually the corporate
Right.
defendant. It's not the individual physician. And you've argued that the corporation, in any event, would not be vicariously liable for punitive damages without at least some showing that they acted improperly as well. Is
Right.
that correct? Plaintiff has argued that because you have not cross-appealed, that avenue, that argument is not open to you. Do you want to address that?
Well, and we actually did cross appeal in this case on
I
a
know.
different issue, and then when I took over the case, it became obvious that the cross appeal was unnecessary.
You had a whole lot of issues, everything from res judicata to
Right.
statute of limitations, et cetera.
But when you win, you don't need to cross appeal, and on this particular issue, I don't think there was any reason for there to be a cross appeal. I don't see that the
You're
argument
just
is
suggesting
clear.
that it's alternate grounds for the Rule
Alternate.
50,
Certainly alternate grounds, yeah.
and you don't think you need to cross-appeal on that?
No. I think that's what this court has said, and it was...
You're not trying to affect the underlying judgment, and therefore you didn't need to have a cross appeal.
Correct. Correct. I guess I also want to, and I think this was something that was alluded to in the questioning of Attorney White, mention the fact that, if she really thought that there had been prejudgment in the case, it was incumbent on her to raise the issue before the panel hearing. You can't sort of just roll the dice and hope that the result is going to be in your favor when you've already concluded that the case has been decided against you. And that's what happened here. According to appellant's counsel, they thought that there had been a case decided against them without the presentation of any evidence. That would be inappropriate. It would be the appropriate remedy at that point would be to raise the issue. In this case, and I hadn't even been familiar with the rule until the court cited it, Rule 80MB4, I think you said. The way to address that would have been to raise it with the Chief Justice of the Superior Court, not wait, go through the panel process, and then raise the issue on appeal. So I think that issue, frankly, was waived by not raising it at the appropriate time. Again, I think it's clear, the law has always been clear that there can be no punitive damage award without an underlying compensatory damage award. I see my time is up, Your Honor.
Thank you.
Thank you.
And Attorney White, you reserve 3 minutes for rebuttal.
Thank you, Your Honor.
Can I follow up on that last point? I mean, you did make the argument that because the issue of vicarious liability wasn't raised or briefed below, but also because there was no cross appeal, it's not open. Obviously, if it wasn't raised or briefed below, that may imply a different standard of review. But since they're not trying to change the judgment, but simply arguing an alternate basis upon which taking the punitive damages away from the jury could be sustained, aren't they entitled to do that?
My reading of Jones is that it's not necessarily just trying to change the judgment. It's raising an alternate legal basis for.
Well, we say that all the time, that we can affirm on a different basis, for example, the different reasoning than the judge gave.
True. I think the issue, though, is not only was this never raised below, as Attorney Tainter was arguing, I recalled that we actually had evidence of Dr. McGuire being in a physical altercation with a patient before this happened with my client. The police
What does
came.
that have to do with anything?
What it has to do with it is if this had been argued in the trial court on the Rule 50 motion, the vicarious liability issue, we would have argued to the judge, oh, they were on notice that this doctor had some problems. The practice was on notice just based on these events, and that was a whole bunch of evidentiary stuff that we weren't able to get in, some we were. But the point remains that the vicarious liability issue should have been discussed and briefed in the trial court so that we could have raised those arguments to prove that, in fact, the practice, I don't know of a single Maine case saying that vicarious liability works differently in the punitive damages context.
You filed your brief. You said, this is why I win. He filed the red brief that says, here's why the decision was right, and added an alternate ground. You didn't file a reply to respond to that alternate ground. Why didn't you?
The reply would have simply said they waived this by not raising it below, and it's clear that they can't do that. They can't raise, sure, the court can find on an alternate basis, but they never argued, and the trial judge never decided anything related to vicarious liability. So without that being, and really their focus was on the clear and convincing evidence standard, and actual malice not being present. Those were the two bases argued for throwing out punitive damages. If they had said, also, by the way, we think that vicarious liability can't lie here, we would have had responses to that. So I think they've completely waived that issue. It's a non-issue in this appeal, not having raised it below. I just wanted to address as well this issue of almost sequentially what happened to Ms. Cutting. And it's ironic because this has already been to this court once before on raised judicata arguments. This is a whole common nucleus of operative facts. They've already argued that everything that happened is all related. His discriminatory bias toward her, the surgery proceeding without consent, and then the falsification of the medical record after. Thank you.
And thank you, counsel, for your argument in this case. As you may have noticed, you have a bit of an audience here today. We have a class from the high school. And if you wouldn't mind, we are going to take a recess briefly, if you would, and then after a few minutes, we're going to come back and meet with the high school class, at least to talk to them. But while we're out, if you wouldn't mind remaining perhaps and taking any questions, I think that would be very appreciated. I don't know if there are any questions, but you might be able to answer some questions that we actually can't. Or are not permitted to. Not that we don't know the answers, but we're not permitted to tell you the answers. So that would be lovely if you could do that. But we'll take about a 5 or so minute recess, a 10-minute recess before we come back in. And as is our usual practice, again, we're not going to issue our decision here today, but we'll take the matter under advisement and issue a written decision in due course. With that, we'll be in recess, and as I say, we will informally come back and meet with the class in a little bit.
All rise.